While reading Indian Polity by Laxmikanth, it is essential to adopt a systematic approach to avoid confusion regarding the various features of the Indian Constitution. To this end, we have been following a structured sequence commencing with the chapter on the making of the Constitution, followed by the salient features of the Constitution, the preamble, amendment of the Constitution, the basic structure of the Constitution, and fundamental rights. In the previous study session, we examined fundamental duties. In this context, do you think this is the optimal chronological order? I believe that upon completing fundamental duties, the chapter on directive principles of state policies should be undertaken next. Therefore, today's session will involve revising notes on directive principles of state policies. Before commencing, I would like to introduce myself. I am Swati, your study partner, and I welcome you all to my channel Aspiration for Learning. Without further delay, let's begin. You may know that the Indian Constitution's directive principles of state policies were borrowed from the Irish Constitution of 1937, which had copied it from Spanish Constitution. These principles are instrumental in Articles 36 to 51, which form Part 4 of the Indian Constitution. Directive principles of state policies, along with the fundamental rights, contain the philosophy of the Constitution, and these are the soul of the Indian Constitution. To attain a comprehensive understanding of the directive principles of state policy, it is crucial to analyze its various features, such as the phrase directive principles of state policy, which signifies the ideals that the state should consider when formulating policies and enacting laws. These are constitutional instructions or recommendations to the state in legislative, executive, and administrative matters. Unlike the instrument of instructions of the Government of India Act of 1935, they are instructions to the legislative and executive principles of state policy aimed at realizing the high ideals of justice, liberty, equality, and fraternity outlined in the preamble. The concept of state policy rather than a policy state is emphasized to establish economic and social democracy in the country. Principles of state policy imply that they are not legally enforceable by the government. So, these are the four main features of the directive principles of state policies. Do you know that the directive principles of state policies aim to establish a welfare state by promoting social and economic justice and ensuring a decent standard of living for all the citizens? Now, we will examine the classification of directive principles of state policies, although the Constitution does not explicitly categorize them. However, they are commonly grouped into three types based on their content and direction, such as socialistic, Gandhian, and liberal intellectual. These three distinct types of policies will be discussed. Starting with socialistic policies, their objective is to establish a welfare state ensuring social and economic justice by focusing on securing adequate means of living for all the citizens, preventing wealth and resource concentration, promoting equal pay for equal work, ensuring worker and child protection, and promoting equal justice and free legal advice also. Gandhian policies, inspired by Gandhiji's ideals, focus on organizing village panchayats, promoting cottage industries, and improving cattle breeding. Lastly, liberal intellectual policies promote international peace and security and opportunities. You are aware that the list of directive principles of state policies we have today was not the same as the original one, because the 42nd Constitutional Amendment Act of 1976 added new directive principles of state policies to the original list, including number 1, to ensure the healthy development of children as per Article 39, number 2, to promote equal justice and provide free legal aid to the poor as per Article 39A, number 3, to take steps to secure the participation of workers in the management of industries as per Article 43A, and number 4, to protect and improve the environment and to safeguard forests and wildlife as per Article 48A. Furthermore, the 44th Constitutional Amendment Act of 1978 added another directive principle requiring the state to minimize inequalities in income, status, facilities and opportunities under Article 38. Additionally, the 86th Constitutional Amendment Act of 2002 altered the subject matter of the Article 45 and made elementary education a fundamental right under Article 21A. Lastly, the 97th Constitutional Amendment Act of 2011 added a new directive principle relating to cooperative societies as per Article 43B. In the Laxmikanth's book of the Directive Principles of State Policy, it is questioned whether these principles are justiciable or not. Sir B. N. Rao, the constitutional advisor to the Constituent Assembly, suggested categorizing individual rights into two groups, justiciable and non-justiciable. The framers of the Indian Constitution made the Directive Principles of State Policies non-justiciable and legally non-enforceable because firstly the country lacked sufficient financial resources to implement them, and secondly the presence of vast diversity and complexity in the country would hinder their implementation. Furthermore, newly independent India with its numerous preoccupations might be overwhelmed by the burden of implementing these policies unless it had the flexibility to decide the order, time, place and mode of fulfilling them. Despite its important perspective, the directive principles of state policies are not above criticism. Let's examine how the directive principles of state policies are criticized, such as firstly, lacking legal force. Criticized mainly due to its non-justiciable characteristics. According to Nasiruddin, DPSPs are not better than New Year's resolution, which are often broken by the second day of January. Secondly, they are not classified or logically arranged. Thirdly, based on 19th century England's political philosophy, Part 4 of the Constitution expresses Fabian socialism without the socialism, which may not be suitable for India in this century. Furthermore, directive principles of state policies lead to a constitutional conflict between the center and the state, between the president and the prime minister, and between the governor and the chief minister. This comprehensive overview of the directive principles of state policies will now be followed by an examination of selected cases that highlights conflicts between fundamental rights and directive principles of state policies. Case number 1 is the Champakam Dorai Rajan case of 1951, where the point of conflict lies in the justiciability of fundamental rights versus the non-justiciability of directive principles of state policy. On the other hand, there is a moral obligation for the state to implement directive principles of state policy under Article 37. The Supreme Court has ruled that in cases of conflict between fundamental rights and directive principles of state policy, the former shall prevail. Directive principles of state policies must conform to and run subsidiary to fundamental rights. The Supreme Court also held that fundamental rights can be amended by Parliament through a Constitutional Amendment Act. Consequently, Parliament enacted the First Amendment Act of 1951, the Fourth Amendment Act of 1955 and the 17th Amendment Act of 1964 to implement certain directive principles of state policies. The second instance is the Golaknath case of 1967, where the Supreme Court ruled that Parliament cannot abridge or take away any of the fundamental rights. In other words, the Supreme Court held that fundamental rights cannot be amended for the implementation of directive principles of state policy. In response to the Supreme Court's judgment, in this case, Parliament enacted the 24th and 25th Constitutional Amendment Acts of 1971. According to the 24th Constitutional Amendment Act, Parliament has the power to abridge or take away any of the fundamental rights by enacting a Constitutional Amendment Act. The 25th Constitutional Amendment Act of 1971 inserted a new article named as Article 31C, which has two provisions. Firstly, it protects laws giving effect to certain directive principles of state policies from being challenged on the ground of Articles 14 and 19. And secondly, it stipulates that such laws cannot be deemed void on the ground of inconsistency with fundamental rights. The third case regarding the Keshavananda Bharati case of 1973, the Supreme Court declared in this case that the second provision of Article 31C as unconstitutional and invalid on the grounds that judicial review is a basic structure of the Constitution and hence cannot be taken away, while the first provision was held to be constitutional and valid. The 40th Constitutional Amendment Act of 1976 extended the scope of the first provision of Article 31C by including within its protection any law to implement any of the directive principles of state policies, and notably those specified in Article 39B and 39C. Actually, the Act enhanced the position of legal supremacy of the directive principles of state policies over fundamental rights conferred by Articles 14, 19 and 31. In this regard, our final case is the Minerva Mills case of 1980, which is highly significant because the Supreme Court declared the extensions of the Keshavananda Bharati case as unconstitutional and invalid. Directive principles of state policy were once again made subordinate to fundamental rights. However, fundamental rights under Article 14 and 19 were accepted as subordinate to directive principles of state policies under Article 39B and 39C. Yet, this doesn't mean that directive principles of state policies cannot be implemented. Parliament can amend fundamental rights to implement them, so long as the amendment does not damage or destroy the basic structure of the Constitution. Now that we have a brief understanding of the conflict between fundamental rights and directive principles of state policies, I believe we can delve into the differences between them. Firstly, fundamental rights are negative, as they prohibit the state from taking certain actions, whereas directive principles of state policies are positive because they require the state to take specific measures. Secondly, fundamental rights are justiciable, meaning they can be legally enforced and adjudicated upon the courts in case of violations, whereas directive principles of state policies are non-justiciable. Thirdly, fundamental rights aim to establish political democracy in the country, but the directive principles of state policies aim to establish social and economic democracy. Fourthly, fundamental rights have legal sanctions, whereas the directive principles of state policies have moral and political sanctions. Fifthly, fundamental rights promote individual welfare and are personal and individualistic in nature, but the directive principles of state policies promote community welfare and are socialistic in nature. Additionally, fundamental rights do not require legislation for implementation and they are automatically enforceable, whereas directive principles of state policies require legislation for implementation and are not automatically enforceable. Lastly, courts are bound to declare a law violating any fundamental rights as unconstitutional and invalid, whereas courts cannot declare a law violating any directive principles of state policy as unconstitutional and invalid, although they can hold the validity of a law on the ground that it was enacted to give effect to a directive principle. This concludes our discussion on the directive principles of state policies. If you found this content informative and helpful, please take a moment to like and share this video and consider subscribing to my channel for more insightful videos. I look forward to presenting another significant topic in my next video. Until then, remain committed to your goals and I know that you have the power to achieve them. Best wishes and regards from your study partner Swati.